Okay, well, thank you. Thanks for inviting me. Thanks everybody for showing up. This is a lot of people for a room like this. Um, so, as you'll all know, intellectual property is often held up to be something like the basic framework for the information economy or information culture more broadly. And it's a very controversial thing, partly because that economy and that culture are controversial. So it won't have escaped your attention that if you look at the New York Times or anything in the high journalistic world, you'll find that there are debates about intellectual property that can be quite bitter, taking place pretty much continuously. And they cover fairly wide ranges in today's world. So it's not just a matter of copyright in books, and hence the Google settlement and things like that. And it's not just a matter of patenting machines anymore. These debates now extend across things like living organisms, because it's a controversial matter about whether you can patent beings, because these beings are to some extent now original creations because of our abilities in genetic science. To what extent can you patent things like original procedures, processes, which may not involve any kind of actual machinery? And can you patent genes? Can you, on the other side of it, how long should copyright terms last? When copyright was originally introduced in the 18th century, the term limit on it was quite short by modern standards. It was 14 years. You could renew it if you were still alive at the end of the 14-year period for another 14 years, but that was it. And for 100 years, copyright had that limit on it. That principle was actually breached in the early 19th century at a moment of romanticism when everybody thought authors were like geniuses and they deserved a lot more. Since then, it's extended, over and over again, to the extent that we now have copyright terms that are nudging on to a century. And there's obviously a big question about whether that actually honours the original intention of copyright, which was to have some kind of bargain between rewarding creative authorship on the one hand and allowing for future creativity by the appropriation of works on the other, by communities. So these are debates that go across today's world. And what I thought I'd do is talk about the history of the controversial character of intellectual property, such that we've got to this point, but do it in a slightly unconventional way, because I think that what a lot of the debates miss is that intellectual property is something that exists really at the level of everyday life, at the level of practice, convention, custom, and so forth, and not just at the level of legal doctrine. Most of the debates that you see focus immediately on issues of legal doctrine, so things like the term, the time limit on a copyright protection term, or the legal notions of originality that go into things like patenting, or for that matter, the kind of cost-benefit analyses that you get when something like the Google settlement comes up before the courts. I think that all of that stuff about doctrine matters, but it misses a huge amount of what makes intellectual property actually consequential and shaping of our world, which is that it extends out into our everyday lives. So, for example, if you're a scientist working in a lab, and the question arises of whether and to what extent you're going to share your insights, information, materials, and so forth with fellow scientists in other labs. Yes, there's a legal component to that, and you have to go through tech transfer offices and the like. But at a more basic level, it's kind of pre-legal, and it has to do with what you take to be the proper conventions of science itself. Is science an intrinsically sharing-oriented activity? Does progress depend on that? And I think that a historical understanding of intellectual property needs to grapple with that character of it, that it's something that exists at the level of the customary, the pre-legal, the sub-legal in a certain way. And the relation between those kinds of things, customary norms and legal doctrines, is actually kind of complicated. It isn't the case that the norms just exist, as it were, and they have their own history, and they then track onto laws. And but nor is it the case that laws just impose themselves on customary norms. There's some quite complicated back and forth process that happens there and has happened historically. And the way that I want to get at that is by saying that we need to look much more than we have looked at the practice of implementation, that is policing. Intellectual property is something that needs to be policed. It's often not obvious to people where its boundaries are and what you should and shouldn't do. So the boundaries that do exist are actually established by actual policing endeavours. And by policing I mean this quite broadly. I don't mean just going out and arresting people. I mean things like surveillance, tracking, digital rights management systems, stuff like that. The policing of intellectual property has become a huge industry of a scale that the public really has no idea about. It's multinational. It's rather secretive, actually. It's very difficult to figure out how big exactly it is because there's nothing like a trade association for it. But it's clearly very large. And it's often been spun off from big trade associations for things like the record industry, so the RIAA, for example, or from big corporations in what's often called now the content industry. So Microsoft had its anti-pirate outfit for a long time. DirecTV had one. DirecTV was called the Office of Signal Integrity, which is a great kind of Orwellian title for it. And the idea was that it would stop people pirating TV signals from the satellite, right? Because you used to be able to, well, you still can actually, get decoding codes, cards that you would put into a decoding machine, and that would allow your television to pick up these signals without paying the fee to DirecTV. And for a long time you could get these in Canada because DirecTV wasn't a licensed broadcaster in Canada. So if you lived in Detroit, you could go across that big bridge, get carfuls of these cards and come back to America. And the Office of Signal Integrity counteracted this. Some of you will know about this because it's to my mind, the best example of anti-pirate tech that's ever happened. So this is about, I would guess, 2001 or so, 2002. The DirecTV quietly uploaded through its satellite over about 6 months little bits of computer code, which were then downloaded into everybody's decoding boxes, the set-top boxes that DirecTV uses. And then as the Super Bowl was starting, on January 30th, 2002, whatever it was, this piece of code was activated, and it simultaneously burnt out something like 300,000 unauthorized decrypting cards. The hacker community to this day knows it as Black Sunday, and it's at least by legend, the last thing that this piece of code did was to burn into the memory of the cards the phrase "game over." That's what the Office of Signal Integrity can do to you. Anyway, this is so. Anyway, I think that we need to look at things like that and not treat them as just manifestations of laws, because they are now, and they have historically been actually for over centuries. That they've actually pushed the boundary. They don't just exercise laws that exist. They create the space within which laws can be made in the future. And they do this by, for example, stretching the definition of privacy, or actually compressing the definition of privacy. So the anti-pirate police, for example, going back centuries, have taken initiatives to go into people's households, to see what's going on there, to take information away from households and then put that information to use. In a certain sense, the DirecTV thing does something like that. But the household is a sacrosanct place in Western political thought going back centuries. So doing this is controversial, and it's always been controversial. And so one of the reasons why one needs to look at intellectual property policing as a practical activity is that it pushes up against these very valued Western political concepts and practices, things that we take to be rather basic to the good society. And the question that it raises is, could you have something like intellectual property without doing that? Would it even be possible? Or is intellectual property itself such a kind of numinous, hard to define, hard to uphold entity that the only way you can actually have it in society is by impinging on other things that we take to be valuable, in particular domestic privacy. So let me talk about this for a minute. I think that a way that we can think about this is in terms of a long-term historical coalescence of two industries. One of which is an industry that's devoted to tackling pirates themselves, loosely so-called. So anybody who's held to be an infringer of intellectual property, whether it's counterfeiting books or copying DVDs nowadays or anything like that. Actually, not nowadays, because DVDs are kind of going out, but 10 years ago, counterfeiting DVDs. That's kind of a practical policing endeavor that involves often actually ex-police officers going around on the beat, recruiting informers, sometimes acting as agent provocateur, for example. The other industry is devoted to what you might call tracking technologies, which depend on embedding or reading traces that go in particular pieces of what you might call content, and that allow you to track where they've come from. Some of these traces are artificial, like watermarks, and some of them are natural. I'll come into that later. They're just things that are intrinsic to particular kinds of content. Both of those industries, the policing industry and the tracking industry, which have now rather merged into one, have long histories. So you can track watermarking, for example, back before the invention of printing. And through the 17th and 18th centuries, when print pirates were active, if you wanted to produce a book and guarantee that people wouldn't pirate it, what you would often do is print the book and then sign every copy. So what's his name, the Tristram Shandy author, Lawrence Sterne, would sign every copy of the edition to make sure that it was authorized. And if you got one that wasn't signed, then you could intuit that it was probably pirated. So the tracking thing goes back a long time. The policing thing goes back a long time too, and it's worth just focusing on that for a moment, because it's in the long history of it that you see the origins of this paradox or tension that I mentioned about privacy versus intellectual property. Because if you go back a long way, back to the Middle Ages and the Renaissance, there were something like intellectual property systems, but they're not called intellectual property. There's no concept like that. That's actually a 19th century concept. It's much more recent than people think. So if you wanted to produce a book, for example, in the early modern period, in the 16th, 17th, 18th centuries, what you would do is go to the guild company that organized the trade of printing and publishing, and you would enter in the title of the book and anything that was distinctive about it into a big manuscript register. And this register gave you then an exclusive right to that work, in principle forever. So there's no time limit on it. But it's not a legal thing. It's a thing that derives from the customary authority of the guild. And insofar as it's legal, it's only legal because things like censorship regimes would point to it as a part of their system. So it's entirely a matter of the authority of the guilds, and therefore of the trade itself. It's regarded as being part of what it is to be a good craft in a well-organized commonwealth, that you have something like this. So the proper comparison that we should have is not with, say, patents, which are different completely, but with things like maker's marks in the silver-making trade. So the idea is that a registration regime like this upholds good quality work for the Commonwealth, and it keeps things orderly. Now, people did, of course, pirate books, but when they did, what you did as a bookseller or printer was to take them to the private court that was run by the trade. This is not a legal thing at all. And the matter would be resolved confidentially behind closed doors by the grandees of the trade. So they might confiscate stock, they might, in extremis, actually expel the perpetrator. And the upshot of that is that if you're not part of the trade, you don't see any of this. So you get a sense that the trade is intrinsically kind of harmonious, which is why a lot of people talk about printing as being kind of intrinsically modernizing and rationalizing. It's that they don't actually see all of these controversies that are taking place behind closed doors. That's one thing you can do. The other thing you can do is go and get a patent, which is very different. A patent is essentially a kind of gift from the state. It's an aspect of royal prerogative originally, so it's not ruled by Parliament or anything like that. It's the direct will of the monarch. or in Venice of the Senate, that that this particular right be given to you. It's not really a right. It's as I say, it's a gift. It's a grace, and they're used for all kinds of things. So it's not just original inventions. You can get a patent on anything if you happen to be favoured by the court. And in the 17th century, especially when Renaissance courts wanted to be very, very kind of lavish, but didn't have tax-raising powers, the selling of patents was used as a way of getting money for the monarchs. And it became a big political controversy throughout many European states at that point. But you get a patent. Now these two protocols then, patents and registrations, are actually in tension because if you have a patent regime, the implicit notion is that it's part of the royal power to give what are essentially property rights across a wide swathe of the economy. The registration regime effectively denies that because it says that we within our trade have the right to assign these things. And in fact, in the late 17th century, the term piracy was invented when a controversy blew up between those two things. So the notion of piracy is actually a byproduct of the clash in politics about those entities. So how did you uphold these? Well, the big principle is that you had to do it yourself. There's no police forces here, really. There's nothing like a professionalized modern police force. What you have to do in either case is to go into action by yourself on your own behalf. But the big difference is that patentees have to do it by themselves, and it's very expensive and very time-consuming, and you have to go through the courts. Registration people, though, people who go through the guild, have the guild on their side. And the important point about this is that guild officers had the right, by custom, to go into the houses of guild members and to see what was going on in them. And state officers did not have that right, at least not in Anglo-American law. So, and London people, for example, thought of this as being a major part of what it was to be English. That your household was your castle and it couldn't be intruded upon by state officers. So guild officers can do this. And really, it's a major part of how literary property, as it was called, came to exist, that the guild could actually go in and make sure that it existed. And this is supposed to be upheld as a just regime because the officers in the guild rotate. So if I'm a warden 1 year, the next year I'm not. So anybody that I police, whose house I go into this year, next year is quite likely to be a warden and to be policing me. So the idea is that it's a golden rule system, that do as you would be done by ends up being the foundation of all of this order. And in the 18th century, though, that kind of system works very well if you're local, if you're all in one city, and if all of your members of a trade are members of one guild, which is never quite true, but it's broadly true for these places. What happens in the 18th century with the development of kind of international trade and Enlightenment as the kind of ideological manifestation of international trade is that the space of policing extends beyond guilds and beyond individual cities. As a result, something like literary property or industrial property, if you want to think of that for patents, goes beyond these kinds of self-policing institutions. And the question becomes, how do you police printers and booksellers who are outside your city, and maybe outside your country too? Because there are those who would hold by, say, the 1730s, that Enlightenment itself depends on the ability to reprint things freely across spaces, across national boundaries in particular. And we owe the current notion of copyright, in fact, to a disastrous attempt to extend policing into those new spaces. Because what happened was in England, the reprinters set up in Scotland in particular to reprint works from London. And the London book trade set up in response to that the first national anti-piracy campaign. What it did was to hire what it called agents who were going to go out on horseback across the country and inspect the shelves of every single bookstore in England for these piracies. And what this was an extension of what had been a right within London of the Guild, but it's now not a right because it's outside London, and it's actually not the Guild that's doing it either. It's a small oligarchy of copyright owning publishers, and they send out letters which are essentially threatening letters. They say, beware that you are not informed against. That's pretty much a quote from this letter. if you submit your piracies to us beforehand, we will replace them with authorized copies. Of course, say one authorized copy for every 10 piracies, something like that. If you don't send them in beforehand, then we will pursue you and fine you, £300 per copy or something like that, some enormous price. Now, this was completely illegal. It's not illegal, right? It's not against the law in the sense that this was something the law had anticipated. It's illegal. It's an attempt to try to establish law on the ground. And it's catastrophic because the Scots react to this with a very big, high-profile public campaign that this is an intrusion on Enlightenment and rationality and freedom itself. And this becomes a long, no-holds-barred tussle, which in 1774 culminates in the House of Lords, with the High Court in Britain, essentially. And the Londoners lose. As a result of that, what they take to be literary property, this whole registration scheme where things once registered last forever, is effectively demolished. And what replaces it is simply a short-term, artificial, statutory right, copyright. So what we take to be legal doctrine actually arises directly out of a controversy about the practicality of policing and going into people's homes, an extension of that old guild principle. And you can see similar kinds of things going on in industrial property at the same time. It's at this point, for example, that the principle starts to be upheld that if you're an inventor, you have a certain expectation that you can get a patent. It's still not a right. It's never been a right, but you can have an expectation of getting one. There's something like a mechanism for getting one. And when you do get one, it's a bargain between you and the public. And the bargain goes that you reveal your discovery, or invention, I should say, to the public. So knowledge will be increased in that way. Enlightenment will be served. But in return, you get a temporary monopoly. And the temporary monopoly is the same length as the copyright, the artificial copyright term now, of 14 years. And what arises out of that is a very interesting technical craft of creating specifications for patents, where these drawings that are put down, these become obligatory in the mid-18th century, they tell you just enough to give the impression that they're giving you the essence of the design. But if you ever actually try to reproduce the design, you can't. It's a very kind of nicely poised technical skill constructing these specifications, and a whole little industry arises for producing them. The other thing that you see at this point is that these kinds of issues of privacy versus property, revelation, concealment, bargains between the individual and the public, which are manifested in practical policing regimes, get wrapped up in all kinds of debates about internationality and cosmopolitanism. So the Enlightenment itself is thought to be at stake. Is it the case that there is something like Enlightenment that extends across national boundaries, that is not constrained to particular domains? And you see this, as I mentioned, with the rise of a reprinting industry. And some of these reprinters are really quite large scale. So in Vienna, for example, the biggest printing house in Europe was run by a man called von Trattner, who had imperial Austrian support for setting up what was this enormous operation, which is more or less completely devoted to reprinting other people's books. And the idea is, because it's cross-border, there's no legal constraint on it, because all legal systems are internal to borders at this point. And there's no moral constraint on it, because Enlightenment depends on this. And it has to be imperially supported, though, because, and this is a kind of nice balancing act, you don't want to be reprinting Protestant, say, Republican works under the auspices, in central Vienna, because you want Enlightenment, but you don't want that part of Enlightenment. So it has to be under imperial auspices, and it is. So Trattner has this enormous operation, but there are similar operations in many European cities. So in Amsterdam, they're reprinting French books. In Geneva, they're reprinting French books as well. In Scotland, they're reprinting London books. In Dublin, they're reprinting London books, and so on. So it's what you start to see by the mid-18th century is a real kind of network of what's often denounced as piratical reprinting. But there's no law against it. And it really cannot be policed. But it gives rise to a whole set of arguments about the proprieties of extending policing across space. And that English case of the threatening letters is one episode there. And it means that what had been seen as largely consensual practices within, say, particular cities now come to be seen as really controversial impositions because they're going outside of the cities, outside of borders, that kind of thing. So by the late 18th century, for example, you will find manufacturers in the Industrial Revolution in Britain banding together to set up what are essentially like vigilante groups to keep the secrets of their factories safe from what they think of as industrial spies coming over from France and later from America. When America goes independent, there are programs sponsored to some extent by the American, they're not directly sponsored by the American government, but they're sponsored by people in the American government, to send agents over to Britain and to learn about the secrets of British manufacturing. So you get this pronounced tension by the end of the 18th century between aspirations to enlightenment and progress on the one hand, which requires sharing and cosmopolitanism, and a really quite, what should we say, hard-line realism about what such sharing might mean in practice. You know, if your exclusivity disappears, then perhaps your national future disappears with it. And this kind of policing became quite strict. So in the 18th century, for example, the British book trade got a law passed in Parliament that said that no book that had been printed originally in Britain could be imported from outside, whatever the outside edition. And because customs agents on the borders had no idea which books had been printed in England, what that essentially meant was that it became illegal to import books, as a matter of practice. And in fact, if you go to the record office in Kew, National Archives I should say now, you can see the copies of ships' manifests and see what was seized by customs agents at the shoreline. And it includes, random selections of books, because they were seizing all books that came into the country. Even if it was just you as a private traveller bringing in books in your chest, they would be seized for that time. And it became, it was pretty much regarded as treason if you were a skilled artisan and you announced that you wanted to leave for America in the late 18th century. So it was the penalties for it were very stiff. And that actually goes back a long way. You can go back and talk about glassmakers in Venice. They used to live on Murano, the island in Venice, where glassmaking goes on, where glassmakers were threatened with death if they left and went and gave up their secrets to another part of Italian towns, another part of Italy. So the issue of spatiality becomes very important. So let me just go on into the 20th century, when you start seeing media proliferate, and with it the problems of policing and the strategies of policing proliferate too. One of the major early examples of this is in the early 20th century, when music piracy was big business. We're talking here about sheet music, so this is a printing industry. It's actually a photographic industry more than a printing industry, come to think of it. But in the period between about 1890 and 1914, reproducing sheet music was a fantastically profitable, huge industry. So popular songs were being reprinted in the millions. Actually, if you tot it all up, into the billions of copies, and sent around through railway networks, and some of them were going abroad as well. And what the orthodox publishers did was to hire an army of what they called commandos to go around the country. This happened in Britain primarily, but I think in other countries as well, to challenge these pirates. And they had the same problems that existed in the 18th century. So these commanders would disguise themselves, they would carry weapons potentially, and they would go into people's houses. And there are stories about threatening people on the doorstep, go in, let us into your house or we will drop you, as they would say. And occasionally the braver pirates would actually challenge this right in court, at which point they would win, because the constitutional right to one's house being one's castle was held to be more important by judges than the right of intellectual property. So at one point, one of the judges in Britain said, the liberty of the subject is becoming of no regard at all when faced with these commandos. And in fact, the music industry did shut down. It's one of those things that's always being threatened in the modern era with downloading, that the music industry was sort of shut down. It actually did shut down in the late 1900s, 1907, 1908, which compelled Parliament to intervene and pass a new Copyright Act that made the pirating of music into a criminal offence, and therefore charged the professional police, the public police, with tackling it. And that's a pattern that one sees repeated from that point onwards, that the content industry recruits an army of private police. They run up against this kind of problem. They bring it to a crisis, really. At that point, it's taken over by the legislature, and the legislature criminalizes that piece of copyright violation. That's a pattern that you see repeated over and over again. So a kind of taking on of this duty by the state happens. You also see the rise of certain kinds of entrepreneurship to continue policing. So by the mid-20th century, groups like the Motion Picture Association of America and the RIAA, in the 80s in Britain, a group called FACT, the Federation Against Copyright Theft, have set up their individual private policing armies, often with the same kind of effect. So when FACT, for example, FACT, it recruited anti-terrorist police, actually, to go out and hunt down record pirates. And what they would do is they relied on an obscure kind of informing law called Anton Pillar orders in the UK, which allowed them to go and get informants among video store owners. So they're talking about video piracy by this point, which gave them secret judicial authorization to intrude into people's houses to find pirated tapes. And there were hundreds of these cases when they did this, until in the end one pirate pushed back in court, at which point the judge ruled that the whole Anton Pillar order regime was illegal. And so that campaign collapsed, at which point Parliament immediately takes it up and criminalizes video piracy. So it's exactly the same pattern that happened and again, it's a product of practical policing. This is not legal doctrine driving more legal doctrine. It's as it were, the constitutionality of policing practices that drives it. These are actually record pirates who were arrested by officers in league with the RIA in the late 1960s. And you find as it grows that this anti-policing industry also consolidates. And it becomes a very hybrid organization too, because it consolidates, it's often spun off from things like record companies or Adobe or something like that. And then it consolidates and creates kind of autonomous semi-private, semi-public organizations, which now have, in the period after about 1980, have tended to ally themselves more and more closely with the kind of world regulatory bodies like the United Nations and the World Health Organization. So a great example is a thing called IMPACT, the International Medical Products Anti-Counterfeiting Task Force, that is run out of the World Health Organization, but originates actually in some of these proprietary pharmaceutical operations. And by now you can find that if there's a conference on enforcement run by something like the World Intellectual Property Organization, you'll find that something like 500 bodies of this kind will actually attend them. So these are huge things. So it's become a very big hybrid enterprise, but it's still plagued with these kinds of concerns. So if you think for the one example of the agribusiness, Monsanto, which is the typical bête noire in this domain, has its own internal anti-pirate squad, and it's funded to the tune of tens of millions a year. I'm not sure exactly what it is now. 10 years ago, it was 10 million a year, and it hires private detective companies like Pinkertons, which have their own rather dubious history, to send out what are essentially agents provocateurs. So, and this is well recorded, what they will do is they'll go into farming communities purporting to be farmers and say to farmers who are using something like Monsanto GMO seeds, you have some surplus seed, let's swap it for my surplus seed. And at that point when they do this, and this is an old practice in farming to do this kind of exchange, Monsanto will then go after the local farmers as seed pirates in their terms. And this is an attempt to try to create legal precedent, if you like, at the expense of what looks like, to a layperson like me, entrapment. I'm not sure whether it technically is entrapment. And the big issue is the oldest issue with the police, which is who guards the guards. There is no oversight of these operations whatsoever by any public body, as far as I'm aware. And people have very little idea that it's going on. So let me that's one half of it, right? So the growth of this kind of practical policing enterprise that involves detective work, alliance with actual police forces, internationalism, a big global industry. The other half is tracking technologies, which also has deep roots. Not just tracking technology, technologies in general of piracy detection and revelation. So you can take it back to, for example, to things like watermarking. This was a device that Robert Boyle, the chemist, invented in the late 17th century to try to detect counterfeit pharmaceuticals and foodstuffs and wines and gems, interestingly. It's basically just a microbalance. So the idea is that what you're actually detecting is differences in relative density. But he said you can detect counterfeit drugs by this, counterfeit foods. You can track things like these technologies down through the centuries, and they've given rise to a whole taxonomy, of which this is my primitive version. So you can have some technologies that are, if you like, preventative. Where are we? Does that work? Yes. So if you think of anti-pirate technologies in general, some of them are preventative, and they can be either overt or covert. So things like encryption techniques, which actually stop you from doing things because they're so obviously there. In the analog era, there was a brief attempt to produce photocopy-proof paper that a photocopier sensor would actually reproduce as just black. Or they could be covert, like anti-copying codes. The prototype for those was a thing called copy code that was created by CBS. You may have heard of this. And it's a significant device. In the 70s, in the time of home taping with cassette tape, digital technologies were just coming along, and in the context of home taping, there was a kind of moral panic about what they would mean, because they held up the prospect of perfect copying, cloning as it was called. So the idea was that with perfect copying and with the ability to do this on tape in the home, you would suddenly have your entire citizenry becoming perfect pirates. And Congress refused to take action about this, even though it was heavily lobbied by the record industry. And what Congress said was, you, the record industry, should create a technological fix to make this piracy impossible. And CBS's copy code was the first attempt to do that. What it would do is, in LPs, it would, remember what LPs are? Analog records, right? It would put in a kind of high-frequency signal, which was supposed to be inaudible. It's called a notch. But a DAT, a digital audio tape recorder, which at that point was the upcoming technology for recording digitally, would recognize this signal and refuse to record onto tape. And it was never actually implemented because inspectors found that you could actually hear this signal. So it actually intruded on the sound quality. But copy code, although it was a bit of a fiasco at the time, created the precedent for all of the different kinds of techniques like that have existed ever since, with the dream that you could actually make piracy a kind of violation of natural law almost in digital technology. So you have anti-copying codes, regional codes, which are much derided, genetic triggers in seed technologies, things like terminator genes, things like that. Or they can be detective ones that reveal things that go on after they've gone on, so watermarking, deliberate errors, that's something that goes way back. So log tables used to be printed, right, in book form. These are books that contain maybe 40 or 50 pages of just numbers in tables. And the producers of these would often introduce one error somewhere. And the idea was that was like a watermark. So if somebody copied the log table, you'll be able to tell because they reproduced the error. DRM tracking, genetic markers, things like that. Intrinsic detective technologies are interesting. There aren't very many of those, but the one big one that does exist is actually has played a major part on the history of broadcast media, because in those countries that have public broadcast systems, like principally Britain in the 1920s with the creation of the BBC, which at that point had a monopoly. The idea of the BBC was that it would be financed by people buying licenses to listen. So if you don't buy a license to listen, you're a listener pirate, according to the BBC. The trouble is that there's no way of enforcing this because you can't tell who's listening. And broadcast signals just go everywhere. It's not like newspapers where you have to actually buy one. They just go everywhere through your houses. They actually intrude into people's houses. One of the complaints about them in the early days. But it turns so this, for example, is I'm not going to go into this, but this was a patent by a company called Secret Wireless that promised to make listener piracy impossible by splitting the signal between different frequencies, by having this thing rotate. So this would rotate and it would split the signal between different frequencies very fast, almost like packet switching, if you like. And the idea was that unless you had a corresponding receiver, you wouldn't be able to reconnect the bits of signal to get your program out. Now, it didn't work very well, and in fact, it was never brought to market, but it's an example of an anti-pirate technology. The one that, I'm not going to go through this, these are anti-taping. It's an example of how much these worries about domesticity actually pervade the home taping things. There was going to be police forces coming to ask you questions about whether you were home taping. So there was a whole culture of policing listening in the 1920s, which in the end came down to technology, because at that point radio receivers would resonate with signals coming in electronically, which meant that they became transmitters. So if you had a directional antenna and you drove down a street, in principle, you could tell which houses were listening at which point, especially if the antennas were not tuned properly. And most people in the 1920s didn't know how to tune stuff very well, so they would resonate more. And the thought was that if you're irresponsible enough to be a listener pirate, you're probably also not responsible enough to be good at tuning your system. So this has an idea about citizenship in it, what it is to be a good moral citizen. So the assumption is, if you're oscillating is the name of this resonant rebroadcasting. If you oscillate, you're probably a pirate because you're that kind of person. So a detective force was set up to look into people's houses with patent crystal detectors, crystal radio sets, right? And this is the first detector van that was established. This is using ex-World War I submarine technology with a directional antenna, and the idea is that you can zero in on particular households to tell which people are unlicensed listeners and then take them to court. And the beauty of this is that it's technological, so in the press this was described as declaring scientific war on piracy. But it doesn't involve actually going into people's houses until you have some evidence. So the promise is that it gets you beyond that perennial problem of policing intellectual property, of going into people's homes. And in fact, the detector van became, as you will know, a kind of symbol for Americans of the tyranny of public broadcasting systems. I can't be the only person who's heard NPR stations in pledge drives say, "Give us money, or else we will have to have detector vans." That's just the idea. And they still exist, I think, in the UK at least, but they never really worked very well. I mean, one of the great things about detector vans is that there's correspondence within the BBC that shows that well into the 50s, they basically didn't work at all. I mean, they were entirely for psychological effect. Partly because, in the early years at least, to do the triangulation, you needed, so this is a directional antenna, and you spin it round, and there's a guy in here using a kind of board with a compass point on it to point in directions from which the signal strength comes. To do the triangulation, you actually need to trundle around quite large areas, so it could take you something like 4 hours to triangulate down to a single house. So you could, in principle, do it. And there were public demonstrations of it, but it turns out that the people who were arrested were actually BBC employees who'd been set up. But anyway, the promise of it is that it gets you past that political issue, that deep-seated constitutional issue about going into houses. So, that's another one of these. The pirate police come and they always arrest your children in their bedrooms. That's an image that goes back at least to the late 19th century, early 20th century. So nowadays what we have is this coalescence of two industries. We have the detective business, the practical policing business that uses often actual police. And we have this techno anti-pirate business. And together what they do, I think, is they shape what we do and don't do, and what we're frightened of, and what we're worried about when it comes to the intellectual property world in actuality. And one should say they also have actually shaped historically what the doctrines of intellectual property are too, because as with the case of copyright, we wouldn't have Anglo-American copyright if it hadn't been triggered by this kind of constitutional concern about practical policing. So that gives rise to questions about which we should be worried, right? But the irony is that although we think that intellectual property and the whole information economy is something radically new, and we talk about it in terms of revolution, the digital revolution, the genomic revolution, and so forth, the things that we should worry about are, in many cases, the most traditional things to worry about. They are citizenship, privacy, property, not just in the intellectual property sense, but in the physical, real property sense. Accountability, freedom of speech, freedom in general, public representation, those things. So these are the things that we've come to recognize over a very long period as being kind of fundamental elements of a just society. And the moral implication of this way of looking at the history of intellectual property is to say that we need to be worried about them again. So I guess I'll stop with what I want to say at that point. But
You mentioned the music industry being shut down at one point. Are there examples of particular industries where they weren't able to integrate the private enforcement into the public law once the courts had ruled it illegal, where it didn't shut down, or is this something that we should be expecting?
the industries will shut down. No, I don't think we need to expect that industries are going to shut down. No, the 18th century case is a great one, where in 1774 this gets to the House of Lords, and that whole system was essentially thrown out and replaced with just the short-term statutory claim, and the London publishing industry went berserk about this. So it was throwing up its hands and saying that in the contemporary valuation, £200,000 worth of property had been destroyed overnight. And that's I don't know what the multiplier would be for modern terms, but that's a large amount of money in the mid 18th century, and they lobbied to get remedies passed through Parliament. They wanted to get a new kind of declaration passed through Parliament of actual literary property, which they failed to do because the Scots actually counter lobbied on it. But there's this moment when an entire system is obliterated. Of what they think is property, and so their notion is that this is apocalyptic, that it's all going to collapse. But the fact is, we don't know of anybody who went under as a result of this, and in fact, many of the titles that were exclusive to particular people in the London trade pretty much remained exclusive to them because they were upheld not by law but by things like blacklisting. So if you're a major London publisher and you own, as it were, Shakespeare, in fact these rights by this point were kind of distributed in a share system among the higher echelons of the publishing industry. So there's about 20 or so firms that are the main London publishing industry. And the way they'd done it was that all of them by this point owned a share of Shakespeare. That means that they all have an interest in policing any piracies of Shakespeare, regardless of the state of the law. So what happens after 1774 is that they uphold this kind of oligarchic system by essentially blacklisting anybody who presumes to reprint or to sell reprints. And that means that you can't get access to all of the other things that they're publishing. And that's a major disincentive. So you find that in practice, the exclusivity it's not ironclad, but it carries on to a great extent, well into the 19th century, and arguably into the 20th century. Arguably now even. But so no, I mean the thought that whole industries are going to shut down is not. That's not something that typically happens. As far as I know, the only case when it's happened is the music industry case in about 1907, 1908. I forget the exact year it was. And what they did was they just announced that they wouldn't issue any more songs until this issue was resolved. And at that point, Parliament came in and said, "Okay, fine, we'll do this." Where that kind of horror story is most prevalent now is in pharmaceuticals, right? Because the pharmaceutical industry represents what it does as being necessarily very highly capitalized, because the idea is that it costs whatever amount. It depends on who you believe, somewhere between 50 million and $1 billion to bring a drug to market, because you have to go through testing regimes and so on. And you have to cost in also all of the investigations that don't lead to drugs coming to market. But that's their line is that is largely upheld by the license income that they get from patents. And if you did away with patents or allowed generics to kind of erode them sufficiently much, then you wouldn't have the ability to have that kind of research world anymore. I have to say personally, I'm very skeptical of that. I've got more skeptical of it too over time, because for one thing, there are now enough experiments with things like open source pharmaceutical research to suggest that a proprietary model is not necessarily the only one that would work. And for another thing, the pharmaceutical industry spends so much more on marketing than it does on research, that the argument is kind of vitiated from that perspective. And for a third thing, it's notoriously the case that what pharmaceutical research produces is actually not particularly great new drugs. I mean, it's Me Too drugs. And most of the real innovations are not produced out of the private pharmaceutical research sector, but out of universities. And then there's a whole translational system, right, that gets it into that world. But so I think that I'm skeptical of the horror story that comes out from the pharmaceutical industry, but that is where you see it now. Where I guess it might happen would be relatively highly capitalized but less kind of consensually essential industries, like opera. Opera's very expensive to produce, and opera companies like the big orchestras through the 70s and 80s got to the point where they were quite dependent on things like broadcasting contracts and recording contracts. And that's been pushed back since then because the recording companies have tended to back out of them. But you could, I think, possibly see a situation in which not opera as an entire form went under, but large parts of the opera companies of the world folded. I think you could see that. Like it was the case about 4 or 5 years ago that there was a particular recording of Tristan and Isolde that appeared, and at that point it was said quite widely in the press that this was going to be the last major studio recording of an opera ever made, for this reason. So yes, I think you could potentially see it with something like that, I think.
So I like learning about the policing of intellectual property, especially people coming into others' homes and finding intellectual property infringement that way. But now thinking of modern day times of all the cases we've heard now, especially college students downloading things like that. So I actually don't know, but how is that policed?
How is that policed? This is part of this industry. There are things. I mean, there are tracking algorithms, right, that will go through and track digital files even through BitTorrent sites and things like that. I'm not sure technically how this is done, but there are there are a lot. It's not. The basic principles of how to do it are not particularly secretive. They're not held in secret, though the particular instantiations are. The interesting thing about that from the perspective of these kinds of concerns is that it's lent itself to the same kind of pushing the boundaries exercise. And there's a couple of cases that I can give, one from Los Angeles and one from Europe. So the Los Angeles case is a company called Media Defender. And what Media Defender did, this was going back about 3 or 4 years, it contracted with, I believe, the RIAA, maybe the MPAA, it's one of the two. And it set up a BitTorrent site. So it set up a BitTorrent site, like Pirate Bay. And so the idea was that if you were, the apocryphal student looking for a BitTorrent version of Avatar or something, you would find yourself at this BitTorrent site. And what it in fact was doing was taking ISP details and then selling them off to this trade association. As I say, I can't remember whether it was the MPAA or the RIA. It's one of the two. And they would then send takedown letters and cease and desist letters and threats and so forth to the individual people on the assumption that the ISP address did translate to an individual. And this is always one of the problems with these things, right? Does it? You can't get within the household, right, to figure out that an ISP address actually tracks to an individual person. That's one of the problems with this. And that again creates the issue potentially of entrapment, because this BitTorrent site wouldn't have existed but for the entrepreneurship of enforcement. The other example, which came a bigger cropper, was a company called ACS Law. And this is a company that's based in Britain but is actually using German protocols techniques. And what ACS Law did was that it somehow got, again, ISP addresses of people who were allegedly downloading copyrighted material. And it would send out letters to these households saying, you have been tracked downloading this material. In order to stave off a ruinous lawsuit, we suggest that you pay a preemptive fine of £500. And people would pay this fine partly because they had the brilliant stroke of genius, this being Britain, that they would allege that the people had not only downloaded copyright material, but the copyright material would be pornographic. And of course, being British, they were too embarrassed to do anything. It's worth £500 not to be embarrassed in the UK. But in the end, enough people reacted against this, and the Consumers Association did a kind of investigation of it, that it started to look like shady practice and like takedown letters. And ACS Law at that point did actually launch lawsuits against some of these downloaders, but it went up into the court system in the UK. And the judge, very interestingly, turned the whole thing against ACS Law and said, you're doing this, it's completely unethical, it's beyond the bounds of any kind of legal propriety, you have no evidence for what you're doing. And at that point, ACS Law backed off very quickly and tried to withdraw the suits, but the judge wouldn't let them. And now it's become a kind of hunt against ACS Law. But there are many companies like that that have tried this game in the US and in Europe. So I mean, yes, it's basically a matter of digital tracking techniques, spiders, bots, things like that. But it leads into these parallel concerns. And the international manifestation of this is with the anti-counterfeiting trade agreement. You heard of this? ACTA. If you search for ACTA online, you'll find tons of stuff about this. So ACTA is the latest in a long string of international agreements, going back through the setting up of the World Intellectual Property Organization, let's go back to the Berne Agreement, actually, and the Berne Convention in the 19th century, which always upgrade intellectual property policing. And ACTA's been negotiated in considerable secrecy, actually, at the insistence of the US government, between the US government and various other governments around the world, New Zealand, Britain, Canada, Japan, I forget where, the European Union, I forget where else. And it's an idea to try to level up policing efforts for all of these domains internationally. And one of the concerns about it is that, at least in the early drafts that got leaked, there was what's called a three strikes law, where private concerns like these, implicitly like ACS Law, can track ISP addresses of downloaders, and on the third alleged offence can simply exclude you from the internet. On the basis that the ISP the provider would then be liable for these huge damages. The financial penalties are enormous for this. And the thing about it is that there will be no judicial oversight whatsoever. So you'd be handing over what's become pretty much a civil right, I think, internet access, to these private corporations with no public responsibilities, to use technologies that themselves are unregulated to dictate that particular individuals can no longer access the internet on the basis of these kinds of allegations. Now, I believe that that's actually been withdrawn from the text as it now stands, but it's hard to know for sure. And there are certainly precedents in certain nations for laws of that kind. The French law, I forget what it's called, has a system like that. And I believe the Irish were going to pass one as well, though I've lost track of what went on with it. So this is, again, this is one of these things where you see it operating in the entrepreneurial world of private policing. Then when it gets pushed back from there, it then gets instantiated into the public policing realm, and now internationally, because that's how these things work these days.
Can you talk more about patenting of living organisms and genes?
Yeah, I don't know terribly much about this. It's a bit of a blank area as far as my own knowledge goes. But this has been a controversial issue, partly for moral reasons to do with as it were, the integrity of creation almost. I mean, it becomes a almost religious thing. So it's now the case, and it has been the case actually for, well, let me go back a bit. It's been the case for centuries that we can create what are essentially new organisms by selective breeding, right? And farmers would do this all the time. And seed, the industry of horticultural seed design, as it were, arose in the late 19th century. And it would do this again by selective breeding at that point. So things like golden delicious apples, for example, are a product of this. And what's changed? But those, for a long time, you couldn't patent anything like that. Any kind of living organism, it was just regarded as intrinsically unpatentable, because it was something like the principle of life meant that any originality that you put into it was kind of peripheral. There was a kind of ongoing stream of life in it, which meant that you were not that authorial about what everything produced. The seed companies, though, the seed industry as it arose from the late 19th century, did do, as I think I mentioned, this de facto business of upholding something like property. So they would send around cease and desist letters to farmers who they thought were growing their own golden delicious, and assume and hope that the recipient farmers didn't know that this was not legal. It was entirely a kind of opportunistic thing. You start getting quasi-legal proprietary rules for seeds in about the 1930s in the United States, when the seed industry came up and decided that it was going to get rules for things like hybrids being proprietary. But you can only really patent them from quite recently. It's something like the 1970s. And that's associated with the rise of microbiology and the idea that there is a genetic identity to particular organisms. And it's really got to be a big deal with genetics being a kind of practical applied science where you can actually insert genes and genetic traits into organisms to create quite bespoke organisms. So things like Roundup Ready maize, for example, in the United States. The idea is that you create a maize with a genetic trait that's been inserted artificially, not through selective breeding, that allows the maize to survive pesticide exposure, which means that you can now put pesticide onto your fields. It'll kill the weeds but leave the maize. It means you can use a lot less pesticide. So it's presented at least as being green. And it is green to the extent that you can use a lot less pesticide, at least until immunity grows up. But so this has come along with a much expanded notion that you can actually patent these now genetically distinct organisms produced artificially and not by selective breeding. It's thought that there's a real difference there. And it's going towards the point where it is the point now where you can actually patent not just plants but animals, and not just microbes but actually, large, visible animals, mice, cows, sheep, things like that. If you put into particular genetic traits into them, and this obviously is a very controversial thing at the level of practice, and not just this as it were quasi-religious spiritual level about the nature of life itself, because it does intrude on these kinds of customary practices of farming communities about swapping seeds and things like that. There's also a way in which you get the pirate technology, anti-pirate technology stuff goes into this in a particular way, because you can intrude into your genetically designed organisms not just beneficial traits, but malign traits, as it were. This is what the Terminator gene was. The idea was that you gave your seeds a genetic trait that would say stop it reproducing or make it die, unless it was in an environment that had a certain genetic trait itself, which meant that if you moved your seed out of the approved intellectual property domain, if you tried pirating the seed, as it were, it wouldn't grow or it wouldn't reproduce, something like that. So hence Terminator, and there are various kind of refinements on that. Now the Terminator gene has never been brought to market, I believe, because it was so controversial. but there are other things which have been, which do things like stunting growth or not turning on the particular genetic trait that you want. So you end up with just like not very good maize or something like that, as opposed to maize with better vitamin properties or whatever it is, or better resistance. So it goes well into the conventional properties of farmers, many of whose practices are now defined as being piratical. And the other trait, of course, is that the upshot of this is the potential for a really big catastrophe, because it's generating monocultures. And monocultures have the scope to be just wiped out if some new bug, some new illness appears.
I just had a question about universities and scientists, especially part of international organizations, and what kind of property rights are given out to them. Because one of the issues that I was thinking about, maybe about 7 years ago, there was a case where scientists had come up with a pathway that created an entire class of drugs, and then they were told by the U.S. District Court that they didn't have any right to any royalties or patents on that class of drugs. So then it sort of created a stopgap for a disincentive for universities or scientists, unless they're part of corporations like Merck or pharmaceuticals, to actually be part of the drug construction creation business. So maybe things have changed since then, but what sort of rights are given to scientists who work for universities?
Yeah, I don't know exactly the answer to that. I think it may depend institution to institution. I mean, I think that the university world as a whole has got a lot more probably adept at doing that negotiation than it was even 5 years ago, I would think. And it's certainly the case that if you talk to researchers, especially in the medical sciences in universities, they will speak as though the world of intellectual property and patenting and so forth and negotiations with the private sector pervade everything that they do now. But there's an interesting thought, what's often thought is that the world of medical research, especially at universities, was transformed, that there was a step change with this law called the Bayh-Dole Act that was passed in about 1980, that said that universities could get patent rights on publicly funded research, on the results of publicly funded research. And what the idea was that it would incentivize universities to do research that would then bring in an income stream to them. Now, there's a couple of things about that. One is that if you look at quantity data on patenting, there is no step change at that point. I mean, Bayh-Dole had a kind of symbolic value, but it actually didn't do very much. Universities were doing this already. It's just gone up like this. The other thing is that that this may have changed again in the last 5 years, but if as far as people could tell about 5 years ago, overall, the extension of universities into this world of patenting medical research products and hoping to get income streams from them has not actually financially benefited the university sector. There was a very interesting occasion, this was about 5 years ago, but it stuck in my mind, when Daniel Kevles, who's the leading historian of this from Yale, came in and gave a talk over in my program over there. And he tends to be kind of constructively skeptical about this whole thing, about the idea of, as it were, the corruption of research by patenting. But the head of the University of Chicago's intellectual property unit, whatever it's called, turned up, and they had a big argument because obviously he's very pro this whole thing. But the one thing that they agreed upon was that overall the universities have not benefited financially from this, because all of the costs involved in setting up tech transfer offices, legal paperwork, licensing, cross-licensing, protective insurance, everything like that, the costs are so enormous that they counteract the income that comes from the patent. So I guess what you could describe it as something like a job creation scheme. But other than that, it doesn't seem to be very good.
Can you talk a little bit about anything that you might have found that's dealing with racial or national bias in the politics of policing? So I'm thinking about how in the 20s and 30s you have the progressive movement and anti-chain activism and how that's sort of linked with anti-Jewish sentiment. You have people like the Ku Klux Klan that are sort of like rallying behind things like that. And so I'm wondering if you see any type of transferring in terms of like that conceptually, in terms of like what the politics are behind like certain groups that are going after. I guess China would maybe be an example of that, and sort of how like there's like this whole sort of sentiment around them and like them copying ideas without sort of the people.
Yeah, that's a very good question. I think it's under researched, as it were. I mean, for one thing, there's obviously a long-standing, pretty much Orientalist notion that China, but then before that, Japan, Korea, Taiwan, had a kind of national trait of copying, right, of being second-hand on the West. And this goes back, I don't know, at least through the mid-19th century. And that certainly played into accusations that were rife in Western Europe and the United States through the mid-20th century about first it tends to rise first with Korea, South Korea, in the 1940s and 50s, but then Japan, then China, now Vietnam. Right? There's a kind of sequence to this, but the idea is that there is a kind of intrinsic tendency to piratical imitation and appropriation, expropriation, that's being exploited by these successive nations. But it's an interestingly kind of double-edged thing, because the sequence, the idea that there is a sequence, is kind of interesting, because it fits with a neoliberal conviction about the basic modernizing process that comes with things like free trade. Because the idea that goes along with the idea of there being a kind of intrinsic imitating thing is that any nation, by imitation, will get to the point where it has sufficient internal creative agencies that it becomes in its interest to have strong intellectual property laws. And this is what happens to successive nations. So you see it first with South Korea, South Korea, Japan, Taiwan. Now it's happening with China, this is the thought. And then it will happen with Vietnam. And then, I mean, God knows where after that. Myanmar, I don't know. Laos, sorry. But, so there's that thing. The other thing is to say within the United States, this is something which is a completely grey area, but it's an interesting factoid that a lot of the public policing of intellectual property stuff is done by this group called ICE, which is Immigration and Customs Enforcement. So it's basically part of the same stuff that does immigration enforcement, and that adds at least a twinge to it. Like, for example, I don't usually get involved in practical stuff, but I got this message about 2 months ago, from a group in Los Angeles that had been targeted in a raid by ICE, asking if I could give any kind of, I don't know, I'm not sure what it was going to be, expert testimony or something like that, in their favor. And as a non-citizen myself, my immediate thought is, well, no, I'm not getting involved. This is immigration. I'm not getting involved with immigration. No, it took me 10 years to get a green card, and the FBI kept getting in the way for some unknown reason. They refused to say why they gave it in the way, but they kept blocking it. And so, I'm not going to get involved in this, because I could, in principle, be thrown out of the country very, very easily. So I do think that it's quite possible that there is a story there about, at least at the level of impressions, what the fact of ICE being the central player in this means.
I think we're at the end. I'm so sorry that we have to evacuate for another class, but thank you so much for
Sure,
doing
thank you.
this.
Thanks, everybody.